Hi everyone. Looks like we are in. So, welcome to our second episode of Polity series. So, welcome to Gallant and welcome to UPSC Buffet Live. So, let's get started. We'll be discussing 2022 questions and we'll be diving a little bit deeper into the facts and certain facts that can help you actually crack the questions. The kind of questions UPSC tend to ask in the past, as well as the kind of questions that we can expect in the coming years. So, stay tuned and listen carefully. Okay. The first one. The first question is, pursuant to the report of H.N. Sanyal Committee, the Contempt of Court Acts was passed. 1971 was passed. The statement itself, first of all, somebody who have heard about Contempt of Court Act might know one thing, that it is passed in 1971. But other than that, which committee recommended it, most people might not know. Even I wasn't aware of that. But the question is framed in such a way that that's not the fact that UPSC is looking for, or that's not what UPSC is expecting you to do. The next one is that Constitution of India empowers the Supreme Court and High Courts to punish for contempt of themselves. Yes, this is actually right. Because if you have been writing this examination, or if you are familiar with the UPSC language, many a times when the Constitution of India is mentioned, or anything that is mentioned in Constitution is given, the chances are it might not be right, because Constitution doesn't really delve deeper into the nuances of legislations or the powers of bodies or even the matters of election as such. So that's a common trait, because Constitution just barely mentions the basic things, and subsequent legislations will be made to give power to that. Okay. So the root power comes from the Constitution only, but mostly details of those kind of things won't be mentioned, except for few things. So we need to be aware of things that are mentioned in Constitution. It's better to know which all things are mentioned in Constitution and assume that things that you haven't found there will be most likely won't be there mentioning in the Constitution. So that's one logic you can apply. So it's easy to, the takeaway from this is easy to learn constitutional mentionings of bodies, procedures and offices. Okay, that's it. And whether or not the speaker's office is mentioned in the Constitution, or the detailed procedure of election of speaker is mentioned, things like that, you need to know whether it's mentioned or not. Make a list of it and assume that things that are not there are not mentioned. Okay, that's one way you can approach it, and that's actually the right way to do it. Okay, so Constitution of India empowers the Supreme Court and High Court to punish for contempt of themselves. Okay, I'll be dealing this question first logically, then I'll delve deep into the concept side of things, the actual content side of things. Constitution of India empowers the Supreme Court and, okay, this can be right, because Constitution can mention, Supreme Court and High Court finds mention in the Constitution, and it can be right. Constitution of India defines civil contempt and criminal contempt. This is something little out of the league for the Constitution, because Constitution doesn't necessarily define into civil and criminal contempt, because Constitution in its bare form itself is a very large document, and if it goes into the nuances, it can get even bigger. That's one reason why most of the things doesn't find, most of the details are not mentioned in the Constitution. So this could be wrong. I'm saying this purely on logic. There is fact to it, obviously, but I'm saying this purely out of logic, that Constitution very rarely defines things, especially in terms of contempt and all. There is a good chance that it won't be defining anything of that sort. So this could be wrong. And eliminating 3 leaves us with 1, 2 and 2, 4. Meaning 1, 2 is right. So even with no actual knowledge, you can reach a point that 1, 2 is right. Okay, that's good thing. In India, the Parliament is vested with the powers to make laws on contempt of court. Yeah, this is true. Because of course Constitution doesn't really mention any details of the procedure. So obviously it's the Parliament who will be making laws on contempt of court, and not necessarily any state legislature or any other body. So this could be right. So logically we can arrive at the answer B. Okay, that's the first thing. And the takeaways and the knowledge you need to have is, the Contempt of Court Act was passed in 1971, and this act deals entirely with the procedure of contempt, and it defines contempt into civil and criminal contempt, and there are characteristics and criteria for which all offenses come under civil contempt and criminal contempt. You need to know those sort of things, because of late UPSC has been asking things at a deeper level, especially when it comes to the basic judiciary and parliament. So you need to know few things about that. So I'll first, right off the bat, the takeaway is learn constitutional mentioning of bodies, okay, or procedures officers, and assume things not in the list to be not mentioned. Okay, you cannot learn everything as whether it's mentioned in constitution or not mentioned. Just learn what is mentioned and assume the rest is not mentioned. Okay, and sometimes you might miss on few things, but it's fine. Don't make your learning process very heavy, very content heavy. This way you can actually eliminate the things, and you can be very light-headed when you are approaching the questions and actually attending the examination. This is one area where most aspirants fail, because they tend to learn a lot of things and there is a good chance that things get mixed up. So it's good to partition things like mentioning of constitution, learn what are there and what all things could be there. If you cannot learn the entire thing, just assume, okay, these kind of things can be there, and assume that rest of it which are not mentioned there won't be there. So that's it. So I'll share some details regarding this. Contempt of court is not defined in the constitution. Actually, it's not defined, but mentioned in Article 129 and 215. As these, that is, the Supreme Court and the High Court are courts of record, and they can punish for the contempt of themselves. Okay, that's the basic wording in the constitution. Under Article 129 for Supreme Court, 215 for High Courts. And also one more thing, High Court can punish for contempt of subordinate courts. This is a critical fact. You might not see this everywhere, but questions can come along these lines. So remember this fact. Then, what is civil court? Civil contempt. Civil contempt pertains to the willful disobedience of court orders. This is again one area where, logically, if you think that, okay, disobedience of court orders can become a criminal offense, but in reality, it's actually a civil offense or a civil contempt. So that's one more thing. Don't go by the logic here. Learn the fact that disobedience of court orders is actually civil contempt, not criminal contempt. This is one area people tend to make it wrong. This is where you need to learn things, in its crux. And the reason is that depriving a party benefiting a legal decree. Okay, disobedience of court. If court orders a compensation to be paid to the aggrieved and the other person is not paying that, then it accounts for civil contempt. Criminal contempt, this is another area, involves actions that either scandalizes or lower authority of court or interfere with judicial process and administration of justice. This can include allegations, baseless allegations or malified allegations against judges and against judges, courts, etc. If a person in malified intention is doing such things that can reduce the power or that can create a negative impression amongst the public or scandalizes the authority of the court, things like that, they account for criminal contempt. Okay, this question come in the backdrop of Prashant Bhushan case, where he openly criticized the judge who was who provided the judgment, but in reality there was a discussion going on whether it's civil contempt or criminal contempt, because personal accusations against judges doesn't account for contempt of court. That's one more thing, but it's not very clearly defined, so don't dive deep into that. So personal accusation of judges, as in if a judge named X is being accused of something, that doesn't necessarily account for criminal contempt. But if the judge in his capacity saying that the judge X is doing wrong and the verdict he delivered is wrong, such a contempt such an action can lead to criminal contempt procedures, and we need Attorney General's approval for contempt of court procedures. That's also there. So learn about contempt of court and the provisions mentioned in the Contempt of Court Act 1971. So that's the basic takeaway. Also the articles, it is mentioned here. It's not defined, but it's mentioned in 129 and 215. The same thing is here. Constitution of India empowers the Supreme Court and High Court to punish for, yes, under 129 and 224. That's it. Moving on, next question. These are the most favorite areas of UPSC when it comes to, every year. Every year we'll be having questions about bills, and it's getting tougher day by day. As in every year, it's the questions, the level of question and the level of knowledge you need to have is getting higher because it's a very basic portion. So try to dive deeper into the bills. Make a table, compare it, and what all bills are there, and compare their things based on few headers, which I'll be sharing now. Okay, so we know that there are three kinds of bills. That's normal bills and money bills, and then constitutional amendment bills. And money bills also has got two other subdivisions like financial bills and financial bill 1 and financial bill 2. Just be aware of that, and make a table based on the headers that I'm gonna give you, and learn it like that only. Don't go by the Lakshmikan structure because it's very heavy and you won't be able to remember things, or you won't be able to internalize things, so that it might be very difficult for you to solve the answer. So first approach, we'll be dealing this entirely logically, then we'll be focusing on the concepts and facts. A bill amending the constitution requires prior recommendation of President of India. Okay, this can be right. Okay, we'll see. When a constitution amendment bill is presented to the President of India, it is obligatory for the President of India to give his or her assent. Okay, a constitution amendment bill must be passed by both Lok Sabha and Rajya Sabha by special majority, and there is no provision for joint sitting. Actually, this particular question, you cannot solve this with pure logic, because developing a logic for questions like these, because these are entirely procedural, there is very little room for natural logic to work. So questions like these actually need fact. This is where the conceptual understanding and the knowledge you are getting is very much valuable and essential to a point. So when it comes to bill, don't try to use your logic or anything. Bills are areas where it's very much defined and very much procedural. So very little room for your imagination or logic or common sense or anything. Just learn how things work and have an idea about that. A bill amending the constitution requires prior recommendation of President. No. Which bill requires prior recommendation of President? It's money bill. When a constitution amendment bill is presented to the President, it is obligatory for the President to give his or her assent. Yes, it's true. A constitution amendment bill must be passed by both Lok Sabha and Rajya Sabha by special majority, and there is no provision for joint sitting. This is also true. So the answer is B. 1 is wrong and 2 and 3 is right. Actually, this provision is in regard to money bill. Okay, that's one thing you need to know. The takeaways are money bill, constitutional amendment bill, and normal bills. Compare them with president assent, then who can present, where also, in which house. These are the basic, but I'll share you a structured note where you can actually learn it more clearly. So for constitutional amendment, the procedure regarding constitutional amendment, as we all know, it's laid in Article 368. Don't confuse it or don't think, just be very clear about the article. 368 is very essential. You will be referring to it in prelims and mains more often. So Article 368 is very essential. It lays down the procedure regarding the constitutional amendment. A bill doesn't require prior permission of the President, and it can be introduced any of the houses. That is one fact that you need to be very aware, that it doesn't require prior permission of President and introduced in any two houses. Despite constitutional amendment bill being a very powerful tool and very powerful bill, and we have got a notion that Rajya Sabha in practice is somewhat inferior to Lok Sabha when it comes to passing in powers of legislation. That is somewhat the idea that we are getting, but don't use that logic or don't go by that thing. This is a actual fact that it can be introduced in either houses. And there is another logic also. These two houses are the ones, the legislative bodies, the upper legislative bodies of our house, the supreme legislative bodies of our supreme legislative houses. So to make a change into the constitution, it won't be limited to Lok Sabha only. Rajya Sabha will have its power because they are also elected representative. They are the mostly the senior members of the parliament, and we need their skills and acumen to to make our constitution the living document it is. So have that logic, and it can be introduced in any of two houses. One more thing. This is where it gets a little, you need to have an idea where exclusive powers of Lok Sabha, LS and RS. Lok Sabha has got exclusive powers on basic things like few things like budget, non-confidence motion, etc. Anything that connects to the accountability, direct confidence, and direct majority of the government in power, Lok Sabha is the one taking the decision. Lok Sabha has the upper hand there. So no confidence motion, then budget passing of budget, things like that, Lok Sabha has got the upper hand. On the case of Rajya Sabha, making changes to the state list and addition of all India services, these sort of things, Rajya Sabha has got exclusive powers. As in, Rajya Sabha need to pass it in special majority, while Lok Sabha has to pass the same legislation simple majority. That's it. So this is how you should be structuring your note. Okay, don't overcomplicate it with words. Try to minimize the words, use shortcuts, short forms, and then mention the key things. That are potential questions. Okay, prior permission is very important. Any of the houses is important. Passed with special majority. This special majority, actually there are 2-3 types of special majorities. You need to be aware of all of that also. That is 50% strength of total strength and 2/3 present and voting. This is a normal special majority. But there is another special majority when it comes to impeachment of president, where it's called absolute majority. That is 2/3, 50% of the strength of total strength, and 2/3 total strength of the Lok Sabha or the body. So that is another thing. So there are 2-3 kinds of special majority. Learn about that. Bills must be passed separately. There is no joint sitting. Okay, this is another important thing. Joint sitting is applicable only for normal bills, and for money bills and constitutional amendment bills there are no joint sitting. Bill regarding provisions must be ratified by at least half of the states. Yeah, again, if there are the constitutional amendment is in regard to any federal provisions, it should be amended by at least half the states by simple majority. As in, these bills will be passed to the concerned state legislatures, and they should pass it with simple majority. But there is one other thing: there is no time limit for them to act. If a bill, that has got federal provisions and that has been passed to the state legislatures, and they need to pass it in simple majority, there is no particular timeline within which they should pass it or return the bill. There is no time limit, and also they can change their decision. This is slightly nuanced, but have this idea: they can change their decision and there is no time limit. President must assent after the bill is passed by 2 houses and cannot return the bill or withhold the bill. Yeah, as in, once the constitutional amendment bill is passed, it's basically like president is out of the picture, entirely out of the picture. All he or she can do is just give the assent, nothing else. No withholding, no delaying, no returning, nothing. So one more fact: 24th Constitutional Amendment Act actually made it mandatory for the president to give assent. Earlier it was not the case. It was 24th Amendment of 1971 that made it mandatory for president to give assent to the Constitutional Amendment Bill. Then we'll look for the money bill. Okay, money bill, Article 110. Again, very important. And also Article 109 that lays down the special procedure for money bills. It's in 109. 110 deals with money bill, and 109 deals with procedures of money bill. So requires prior permission of president. Yes. Presented only in Lok Sabha by a minister. Again, yes. Compare it with Constitutional Amendment Bill. Constitutional Amendment Bill can be presented in Rajya Sabha and can be presented by anybody, not just a minister. A private member can present it. Rajya Sabha cannot return the bill. Amendments made by the Rajya Sabha is not binding. Bills must be returned within 14 days. There is very specific details mentioned. That is, cannot return the bill, and they can amend the bill, but it's not binding, and the bill must be returned in amended form or without amendment within 14 days. Basically, Rajya Sabha, all they can do is just see the bill and discuss it. Nothing impactful is going to happen when a bill is passed as money bill. This is exactly why there is a misuse of provision of money bill, especially when the party that is in majority in Lok Sabha doesn't have that much numbers in Rajya Sabha. So they tend to take the money bill route, which is an act of colorable legislation. So this is often criticized and often controversial, because the one who is certifying a bill is money bill is a speaker, and speaker obviously belongs to the party in power. Sadly, there is very little separation between interest of the speaker and the party in power. So things like that can happen. There is misuse of provision is happening. Aadhaar bill, I think few bills were there. Aadhaar bill was the one that has been passed as money bill, and it's entirely bypassed Rajya Sabha. So this has been in a case, and the Supreme Court has ordered that there should be clear criteria for certifying money bill, and it's not just simply discretion of the presiding officer, that's speaker. Certification of speaker when transmitted to Rajya Sabha. That's it. These are the few facts. Try to understand them, okay? Since these are not very logical in terms, because it's basically laws and legislations, there is very little logic to it. But if you look deep, there are logic to it. As in, money bill is something that deals with the government and day-to-day functioning of the government, and it represents the confidence of government. So money bill won't have the Rajya Sabha won't have a much say in money bill, because they are not directly responsible to the people, or they are not the government in power. Their tenure is entirely different from Lok Sabha's tenure. They have got a fixed tenure. So things like that are there. And Rajya Sabha is a continuing chamber. It cannot be dissolved. So that's it. Then another question. The Constitution of India classifies ministers into 4 ranks. That is Cabinet Minister, Minister of State with independent charge, Minister of State, and Deputy Minister. Okay. The total number of ministers in the union government, including Prime Minister, shall not exceed 15% of total number of members in Lok Sabha. Okay. Right off the bat, this can be wrong, because Constitution doesn't really classify ministers as such. So there is a good chance that this could be wrong. And this is a very common fact that we study, Schedule 10, anti-defection law. And I think it's Article 75. Article 75 and Article 224, I guess. I have to look at that. So it's Article 75 and Schedule 10. That is where this provision has been introduced, that total number of strength of Lok Sabha, as in total strength of ministers, shall not exceed 15% of numbers in Lok Sabha. Again, very important thing, sometimes everything in the statement will be given right except for this Lok Sabha. Instead, it will be mentioned Parliament. Then it becomes entirely wrong, because Parliament houses Lok Sabha and Rajya Sabha. So this 15% of total members of Lok Sabha only, not Rajya Sabha. Rajya Sabha is not in the picture of the upper limit of ministers. And you can imagine why this sort of provision has been introduced, and it has been introduced in the anti-defection law Schedule 10, because having too much ministers, and due to political coalitions, everybody will be given some portfolio that can exceed and that can put pressure on the exchequer. That's the reason why it has been capped to 15%. So that's one more thing. This is factually right. There is no logic to it. The only logic is that this would be wrong, assuming that Constitution, there is a very little chance of Constitution defining these 4 ranks and all. Constitution doesn't even define ministers as such, or powers of ministers, except for maybe Prime Minister or Chief Minister. Other than that, nothing is mentioned in the Constitution. So this is right. Again, answer is B. We'll look deep into the facts. That Article 75 and 164 places limit on strength of Council of Ministers in centre and state. That is 75 places the limit as 15%. That's the upper limit. 15% of the strength of Lok Sabha. That's the maximum number of ministers the central government can have. At the same time, Article 164 says that 15% of the strength of the House, whatever that number is, that's the maximum number of ministers the state government can have. But there is another caveat to it, because in Article 164, a lower limit is specified. This is the upper limit. This is the maximum number. 15% is the upper limit, the maximum of 15%. But in terms of Article 164, that concerns with state legislative assemblies, a lower limit is specified. That is, number of ministers should be greater than 12. An exception to this is only Delhi. So that's another case. Delhi is an exception for this. So I don't think it doesn't come under this Article 164 provision. But this is one thing you need to know, because in the case of Article 175 and the central government, there is no lower limit mentioned. But in case of states, there is lower limit mentioned as 12 and upper limit mentioned as 15% of strength of the House. Imagine if the House has got 100 members, 15% will be like 15. So there will be total number of ministers should be maximum 15, and the lower limit will be 12. Okay, that's it. Which of the following are exclusive powers of Lok Sabha? Okay, again, exclusive powers of Lok Sabha. To ratify the declaration of emergency. Okay, to pass a motion of no confidence against Council of Ministers. To impeach President of India. We'll approach it logically. We know that Lok Sabha is the only house that deals with the conference of government, the non-conference, everything. So this is an exclusive power of Lok Sabha because they are the ones directly elected and they are the ones holding the ministries. Not just ministry, they are the ones forming the government. So the non-confidence or the confidence motions are directly are presented in Lok Sabha only. Rajya Sabha doesn't really have any say in this because Rajya Sabha is an entirely different in its tenure, in its working, because it's a continuing chamber and there is no direct elections and they've got a fixed tenure, things like that. But on the case of Lok Sabha, the tenure can end. Lok Sabha can be dissolved if there is thin majority and shifting of parties or allegiance can happen and the conference is lost. Things like that are there. So conference, money bill, budget, things like that. Lok Sabha has got a exclusive power. So from that I'll know that 2 is definitely there. So options without 2 I'll eliminate. To impeach President of India. Okay, that is already gone. You don't even need to know that fact. To ratify declaration of emergency. See, emergency is such a drastic measure that the country is taking, and there should be sufficient safeguards to ensure that it's not arbitrary. Sadly, in the past we have faced certain misuse of these emergency provisions. So in order to prevent that, there will obviously be some safeguards. And in this particular case, Lok Sabha and Rajya Sabha, they are actually involved in declaration of emergency, because to ratify the declaration of emergency, there should be special majority in Lok Sabha and Rajya Sabha. Okay, that is there. And the discontinuation doesn't really require a special majority of Rajya Sabha and Lok Sabha. It just requires simple majority in Lok Sabha. So declaration actually needs more. It's a more difficult process because it requires special majority in both houses, Lok Sabha, Rajya Sabha. But at the same time, the discontinuation or disapproval of Lok Sabha emergency motion requires only simple majority in Lok Sabha. So this is not the exclusive power of Rajya Sabha, Lok Sabha. So that is gone. This is gone, and the answer is 2. We look into the facts. National emergency. Basically learn about what all are the emergencies. Since the question is about emergency, it's a good time to learn what all emergency is. Now you get the point, right? When we are going through the PYQs, we are not just dealing with the questions. We are dealing with the concepts, the kind of concepts. Since the mentioning of emergency is there, and emergency is one thing that is we should be covering, we can cover it through questions. This way you can learn it more intuitively and internalize it better. That's the reason why I am taking this sort of approach. At first you might think that, okay, this seems very unorganized, or you may think that this is non-linear in nature, because I am not going by the terms of Lakshmikant, because that you have already learned, that you have already been through classes. Now you need the skill, mindset and logic and the sufficient conceptual understanding to actually clear the examination by marking the right questions, or choosing the right answers and getting the right score. So this is where actually the art of answering comes into the picture, and how you can use your knowledge and how you should be studying to ensure that you are marking things right and the logic and everything is in the right place. So national emergency, you need to know the article. Again, these are the non-negotiables when it comes to polity. Articles 1, 350, 352, 356, it's very logical only. Just adding 4 from each of these, we'll get the thing. And 352, 356, 360. Okay, national emergency. The resolution for disapproval, 1/10 that if national emergency is passed and it is continuing, the 1/10 MP can put a notice to the speaker or president that we need to discontinue the emergency that is currently in power. So a special sitting within 14 days will be arranged, and if the resolution passes with simple majority, the emergency is revoked. This is very crucial, because once emergency is in place, the procedure for actually declaring emergency is very hectic and it has got multiple safeguards. But at the same time, the procedure for disapproval is much easier, because only 1/10. Think about that. 1/10 MPs are needed. It's very low number actually, considering the other provisions, and special sitting within this and simple majority. Here, simple majority in Lok Sabha only. It's not simple majority in Rajya Sabha. Be very careful. It's Lok Sabha only. Okay. Resolution for continuation. If a national emergency is in place and it's about to end, and resolution for continuation is placed, both houses needs to pass it in special majority. That's one thing. Also, another thing that can go wrong when you're not very clear about the questions concept, that is, during emergency, center can give executive directions to state on any matter. Any matter. It's an extreme statement, but it's right. Okay. Center can give executive directions to any matter. Okay. So there are times where extreme statements can be right. Then life of parliament can be extended by parliament for 1 year at a time. Similarly, state legislative assembly can also be extended to 1 year. Again, this is another important thing. Legislative power of state is not suspended, but it's overridden by parliament. That is, bills of the state legislatures are often passed by the parliament. That doesn't mean that legislative power of state is entirely suspended. State legislatures will be functioning, but it is overridden by parliament. There will be constant parliamentary oversight, so that is there. This is important to note, and legislative power is not suspended. This is also another fact you need to know. Then, since UPSC has been asking few things like how many delimitation commission has been constituted in the past, things like that have been asked, and emergency being a key area, we need to know how many times emergency has been passed. This might be a one-liner question, so if you don't know, you might overthink and confuse it, and it's better to know which all years it has been passed. As in, we know that in Indo-China War in 1962-68, then India-Pak War. Actually, during this time, another India-Pak War has happened, but once this emergency was already in place, it was not necessary to declare it again. 1971-72 India-Pak War, 1975-77 internal disturbance. When we say emergency, we all think that it's just the 1975 emergency that has been declared, and we might think that okay, the emergency has been declared only once, but in reality it has been declared actually 3 times on account of major wars. And also in 1999 during the Kargil war, emergency was not declared. So don't go by that logic also. This is a proper fact, learn it. Then, government law officers and legal firms are recognized as advocates, but corporate lawyers and patent attorneys are excluded from recognition as advocates. Absolutely no idea. We are not going to cover anything about this. I don't really think there is any particular source to this, any common book that we refer. So, I don't know. We have to see. Bar councils have the power to lay down rules relating to legal education, recognition of law colleges. This is actually right. This is slightly factual in nature. There is very little logic you can use. But this question is often asked in every test series. So if you take a polity test series, bar councils will be mentioned, and they are the ones dealing with the legal education matters, rules of legal education matters. So bar council is a very powerful body, and they have the power to do this. This is right. I know it factually. There is no logic to it. This is factual only. And in this question, I don't really have any knowledge or fact. So government law officers and legal firms are recognized as advocates, but corporate lawyers and patent attorneys, why not corporate lawyers not mentioned as advocates? That's one doubt I had. So I think the way this is framed kind of questions a doubt. Like, what's the reason for corporate lawyers not being recognized as advocates? They are fighting the cases in various tribunals or courts for that matter, so they will definitely be advocates. So what's stopping them? Patent attorneys, I don't really know exactly their line of work, but corporate lawyers, there is a good chance that they could be regarded as advocates. So this can be wrong, but I'm not 100% sure, but I think this can be wrong. So I'm taking a slight risk because I know this is right, meaning 2, and I'm left with 50-50. So I have to choose an answer. So it's worth taking a risk because I've reached this far, and it's worth taking a risk. So I'll be going with corporate lawyers are not advocates. I feel it's wrong. So I'll be eliminating this and going at the answer as B. And luckily I was right. You can be wrong, okay, the way you think about it, because it's a very factual thing and there is a 50-50. But if you reach a 50-50, definitely choose an answer. There is a good chance that with subsequent practice, the kind of answers you will be having will cross the 50-50 mark, and you will end up with more answers right if you choose between 50-50 options. Many people will get stuck between 50-50, I know, including myself. But the thing is, you have to attend the question. don't leave it, and look for any clues that pushes it to the other side, as in whether or not to choose it or eliminate it. If you find something that can, there is something that could be eliminated, just go for eliminate that option, choose the other one. If there is something that there is no if there is no much burden of proof, then go for the positive approach and deal with that. Imagine 10 questions are there. If you manage to get 10, 50, 50, if you have reached 50, 50 in 10 questions, and if you manage to get at least 6 of them right, and that's worth it. If you keep on practicing the questions, and you will be developing the sense of intuition, this can really help you actually cross that 6 mark also. Okay, this is one thing that everybody is struggling with, I know, but you can cross the mark with subsequent practice. And also a few things you can look for is burden of proof, as in reading that statement, how likely this statement is, how likely or how easy for that statement to be right, and also try to find something that doesn't suit your logic, then eliminate it. Go for it, take the risk. There's no way around it, just take the risk. And it's not taking the risk when it comes to 50-50 is the risk. Remember that. Okay, then moving on. Actually, there are no particular things to look for here, but learn about Bar Council, the kind of body, whether it's statutory or not. Then who is the chairperson, who appoints him or her. Okay, these are the basic things you need to know about Bar Council. And what do? Their jurisdiction. Okay, I'll just use it as a bullet. Then who appoints and then their powers, role. Okay, anybody, if you are studying, go through these things and study only this much. Don't just dive very deep into everything. Just first of all start with whether statutory or not, and who appoints, like the chairperson, who is the chairperson, then who appoints him or her, then their powers. Okay, when it comes to powers, it might be very lengthy, but just look for some keywords like legal education, something of that sort is there. Just remember that. You don't need to go through the entire powers. If it's the very last thing and the number of the roles they are having is very high, you don't have to remember everything. Just look for something very important like the legal education, things like that. In the case of Bar Council or in any other body, if such a thing is mentioned, remember that. Okay, don't need to go through the roles entirely, because that's not really rewarding, because only 1 or 2 questions regarding statutory bodies will be asked, and most of it can be solved logically. So that's it. That's how you should be studying statutory bodies. Anti-defection law. Anti-defection law, as we all know, it's in the 10th schedule, and it was first introduced in 1985, and later an amendment was passed, and it was passed during the era of Rajiv Gandhi. So that's important, because questions has been asked in kind of legislation passed during who was the prime minister during that time. So it was first passed during the time of Rajiv Gandhi in 1985. The law specifies that a nominated legislature cannot join any political party within 6 months of being appointed to the House. The law does not provide any time frame within which the presiding officer has to decide a defection case. Okay, first of all, this is an easy fact. Okay, because when it comes to anti-defection, there are only few provisions mentioned, explicit mentions in Lakshmikant also. It's explicit provisions are mentioned, and it's clearly mentioned that a nominated legislature can join a political party within 6 months. But an independent member, that is one who contested without any party background, cannot join any political party after winning the election. If he or she wins the election, then his candidature will be annulled, meaning he will be disqualified. So a nominated member can join a political party within 6 months, not after 6 months, within 6 months. But at the same time, an independent member cannot join a party after winning an election. So if he or she does that, they will be disqualified. But they can change their coalitions. That's not an issue. That's how they bypass it. The independent members actually, after winning the election, they shift their coalitions, because that's not really under the ambit of anti-defection law. This is also another thing when you are writing answers about anti-defection law, because use of coalition can actually help you, because you don't need to change the party. All you need to change is the coalition, and coalition is not very defined, and it's loosely defined, and it doesn't come under the provision of anti-defection law. So have an idea about that. Also, again, this is the Achilles heel when it comes to anti-defection law, because the presiding officer, the speaker, is the one who is deciding, and in most cases the horse trading is done in favor of the party in power, and speakers are not as non-partisanship as the other people. So it should be we should be very aware of that also, that speaker actually in principle they should be as detached as possible, and they should be somebody alleging having allegiance to any political party. But since we can imagine the speaker themselves are an MP, themselves is an MP, so we cannot expect them to not have a political allegiance irrespective of the party. The speaker who is an MP, an elected MP who contested an election on the background of a particular political party. So that's it. Then the law does not provide any time frame within which presiding officer has to decide a defection case. Yeah, this is actually an issue, and Supreme Court has intervened multiple times that there should be a set timeline, and also the decision making power of presiding officer should be taken away, and it should be replaced by a quasi-judicial independent tribunal, so that to ensure fairness. So this is right, this is wrong. 16B, so that is right. Then another one, Attorney General of India and Solicitor General of India are the only officers of government who are allowed to participate in the meetings of the Parliament. Okay. We know one thing. Attorney General is allowed to participate in the meetings of Parliament, and he can be member of committees also, but he's not allowed to vote, obviously, because he's not a member of Parliament. So he has the right to audience of all Parliament and state assemblies across the country, so that is there. But Solicitor General, though they like Attorney General, Solicitor General is subordinate to Attorney General, the Solicitor General is not mentioned in the Constitution, though they have similar powers but only subordinate to Attorney General. So Solicitor General won't be having the same power as Attorney General. It's a subordinate body. So this is wrong. According to the Constitution of India, Attorney General of India submits his resignation when government of which appoint him resign. Actually, no. Constitution doesn't define any of this. This is a practical thing. As in, Attorney Generals are mostly appointed by the government in power, because Attorney General's primary purpose is to provide legal advice, firstly, and then defend cases against the government, or push cases in government's favor. So obviously, the Attorney Generals are chosen based on their allegiance to the government in power, and there is a good chance that when the government that has appointed the Attorney General resigns, when the government actually resigns, okay, the resignation happens simultaneously, but it's not a mandatory provision. Imagine if another government is coming and the Attorney General is kept, there is a good chance that they can be kept also. There is no provision for that, but usually in practice the Attorney General resigns, because the way they are appointed is to defend the government that was in power. So it kind of brings in the conflict of interest, and usually the Attorney Generals resign. And you need to know a few things, that Attorney General of India, despite being a constitutional body or constitutional office, is not barred from practicing. Okay, that's one more thing. And an Attorney General can practice in law courts, and that doesn't account under Office of Profit. That's a very important thing. That's it. Learn about Attorney General and Advocate General. These are both constitutional bodies, and their articles, that is you need to know about, and their powers. That's it. Powers of audience and membership in committees, if any. Okay, that's it. It's not a very complicated thing. Attorney General just need to have an idea about that. Also, Solicitor General is not a constitutional body. Okay, writs, very important. Article 232 and 226. They are the ones dealing with writs. Mandamus will not lie against private organization unless it is entrusted with public duty. Right off the bat, if you are learning writs, you need to understand few things. It's always better to know the meaning. These are all Latin words. It's always better to know the meaning. Habeas corpus, bring the body. Mandamus, we command. Certiorari, to certify. And quo warranto, under what authority? Then what? These are the mandamus, certiorari, quo warranto. The prohibition, yes. So we prohibit. So having the idea, the English meaning or English meaning of that Latin word really helps when it comes to, in actually writing the examination. So mandamus means we command. That is the higher court is commanding a lower court or a body to take a particular action. They are commanding it. So mandamus will not lie against a private organization unless it is entrusted with public duty. Makes complete sense, because how can a court order mandamus or command some body to do something if it's not public body, or it's a private body not entrusted with public duty? Yeah, this is true. Then mandamus will not lie against a company even though it may be a government company. Yeah, this is where you have to be a bit careful. A lot of people actually marked it wrong, and it was people were waiting. There was a lot of debate going on until the UPSC actually officially released the key. That mandamus will not lie against a company even though it may be a government company. Yeah, here it's mentioned like even though it may be a government company. There is a good chance, because if the government company, the kind of work they are doing or the kind of thing the work they are undertaking, it's not completely public in nature. Even though it's a government company, their work is not entirely public related, or if it comes under other provisions like Official Secrets Act or any national integrity, national security concerns, it won't be, mandamus will not lie against them. Okay, so there is a good chance for that. And also the way the statement is framed, that even though it may be, even though it is not given like, even though it is not a government company, it's given like it may be. So this could be right, unless this is right. This is right. Any public minded person can be a petitioner to move court to obtain writ of quo warranto. Yeah, this is where the concept of locus standi comes into the picture. Locus standi means the one who is the aggrieved. So quo warranto is the only writ where the aggrieved, and also habeas corpus is there, but when we say that locus standi is the only writ that doesn't require locus standi. Locus standi means if I am the aggrieved and I need to be the one filing the case or the petition, but somebody can file a case or a petition on behalf of me or in public interest. Basically, public interest litigation is something that has got the most diluted requirement of locus standi. So that's one important thing. Quo warranto is the only writ that has got that doesn't require locus standi. Locus standi means the aggrieved person need to be present, or aggrieved person only can file the petition. But without the locus standi, or the laws that doesn't require locus standi, like public interest litigation, the aggrieved is not required. Anybody can file the petition in public interest. So any public minded person can prove. Yeah, this is also fact. Mandamus is fact, and I think the answer is D. Okay, we learned few things. That about writs, you need to have an idea that, first of all, what does that mean? That is where the meaning part of it comes into the picture. So meaning of the writ, then available to which all parties, and it's better actually to learn that which all parties are excluded, because the available list might be large. In some writ it will be large, so it's better to learn not available. So that way you can assume that if then something is mentioned is not in the not available list, it will be available, it will be there in the available list. So certiorari means to certify, not available to private and legislative bodies. Prohibition, not available against administrative, legislative and private entities. Actually certiorari is not, private entities are actually mostly not here. Only in habeas corpus the private entities, the petition can be filed in against private entities. Quo warranto, only writ locus standi is required. Mandamus not available to enforce a contract. Yes, this is explicitly mentioned, that mandamus, court cannot command or use mandamus writ to enforce a contract. So that is very important. Though mandamus means we command, and that is what they usually do, but it is not available for enforcing a contract. Then another one. With reference to Deputy Speaker of Lok Sabha, consider the following statements. Okay. As per the rules of procedure and conduct of business in Lok Sabha, the election of Deputy Speaker shall be held on such a date fixed, Speaker may fix. Okay. There is a mandatory provision that the election of a candidate as Deputy Speaker of Lok Sabha shall be from either principal opposition or ruling party. Okay. Deputy Speaker has the same power as Speaker when presiding over sitting of houses and no appeal lies against his ruling. Okay. The well-established parliamentary practice regarding the appointment of Deputy Speaker is that the motion is moved by the Speaker and is duly seconded by the Prime Minister. Okay. Here, some level of logic is applicable. First of all, there is a mandatory provision that selection of candidate of Deputy Lok Sabha shall be from either principal party or opposition party. There is no mandatory provision. Basically, they are electing a speaker amongst themselves, and it mostly happens to be the one from the principal ruling party. And the convention I think convention since 1999 is that the deputy speaker is from the opposition party. It's a convention, it's not a law, or it's not under the rules and procedure and conduct of business of Lok Sabha. It's just a convention that deputy speaker is from the principal opposition party, and the case of speaker is not convention. It's based on the election. They elect a speaker amongst themselves with simple majority. So there is no mandatory provision. 2 is definitely not right. Then we are left with 3 is right. Deputy speaker has the same power and speaker. Yeah, that makes sense. 3 is right. We are left. We are eliminating 2. Then we have to choose between 1 and 4. As per the rules of procedures and conduct of business of Lok Sabha, the election of deputy speaker shall be held on the date that speaker may fix. Okay, even if you don't know the fact, but this seems right only. Even if you don't know the fact, it seems right only, because speaker is the one who can fix the date. Then the other person who is capable of doing that is president only. But president fixes the date of election of speaker, not the deputy speaker. That's one thing. Then there is a well-established parliamentary practice regarding the appointment of deputy speaker is that the motion is moved by the speaker and duly seconded by the prime minister. Compare 1 and 4. This seems very off. This is where knowing the UPSC language really helps. This seems very off when you read it with this, because this is not really a proper procedure or not a provision that we often hear or we come across even. So this is most likely wrong only. So 4 is wrong, then 2 is wrong, and thereby we arrive at the answer. And about the fact things, the election of deputy speaker is held on a date as speaker fixed, and the election of speaker's date is fixed by the president, and the pro tem speaker, that the one who's presiding over the first sessions, is appointed directly by the president. There is no election for pro tem speaker. President select an MP and appoint him or her as the pro tem speaker. They proceed the oath taking ceremonies, and after that, the speaker's election date is fixed by the president, and then speaker is elected, and speaker fixes the date of election for the deputy speaker, and it continues. And there is only conventions. The deputy speaker has to be usually is from the principal opposition party. That's the convention. But ever since the 17th Lok Sabha, there has not been a deputy speaker, despite the deputy speaker being a critical and important constitutional body. We don't have a deputy speaker as of now. Since the 17th Lok Sabha, we don't have one. So few things regarding speaker's power, not the entirety but the basic things. Speaker doesn't vote till the event of tie. No casting vote by speaker till date. As in, speaker, though he is a member of parliament, member of Lok Sabha, cannot vote or doesn't vote until there is an event of tie, and he cast a casting vote. That if there is equal proportion of people supporting and opposing a bill is there, speaker can cast a vote. That is called casting vote, and there has not been a casting vote till date. We have not reached such a deadlock so far. Under constitution, chairman of RS can cast on the other hand. Similar to speaker, the presiding officer of Rajya Sabha is the vice president or the chairman of Rajya Sabha. He or she doesn't have the power to vote because they are not members of that particular house. That's one other thing, because vice president is the ex officio chairman of Rajya Sabha, not the member of Rajya Sabha. So can cast only casting vote, and no casting vote is in this removal resolution also cannot preside. Yeah. Also, if a resolution of removing the speaker is there, the particular speaker cannot preside. But at the same time, the speaker can vote on that thing. That's very important. Remember that. If a resolution for removal of speaker is there, he or she cannot preside, but can vote. But at the same time, if the resolution of removal of vice president is there, that's the chairman of Rajya Sabha, no, like, first of all cannot preside and then cannot even vote. So speaker, deputy speaker cannot preside when resolution is in progress. Okay, tender resignation. Speaker tender resignation to deputy speaker. Yes. President fix the date of election of speaker as per rules of procedure. Speaker elected by simple majority by Lok Sabha members, like we discussed. Pro tem speaker is appointed by the president. That's it. So that's all for today's session. And I really hope that you are understanding how to learn. More than the conceptual understanding, I am trying to align your thought process and the learning strategy to the exam demand. We'll be discussing these sort of questions, these sort of concepts. I'm not diving deep into the concepts because that's a bit counterproductive, because you need to know more about how to eliminate things and the particular nuances of things. So I'll be sharing the nuances and at times details regarding that. So try to go through these notes that or the presentations I pick in between and take a screenshot or something. You can really use that later and add it to your notes. It's like a quick revision and easy understanding, so you can internalize it better. So that's about it. You may take a screenshot from the videos. So